Undue hardship is a crucial concept in employment law, particularly when it comes to accommodating employees with disabilities. But what exactly constitutes an undue hardship, and how does it impact both employers and employees under the Americans with Disabilities Act? Undue hardship refers to an accommodation that would cause significant difficulty or expense for an employer. Under the ADA, employers are required to provide reasonable accommodations to qualified individuals with disabilities, unless doing so would impose an undue hardship on the business operations. Several factors are considered when determining whether an accommodation would cause undue hardship. These include the nature and cost of the accommodation, the overall financial resources of the facility or employer, the number of employees, and the impact of the accommodation on the operation of the business. Let's look at some common examples of undue hardship. A small business with limited resources may not be able to afford costly modifications, such as extensive building renovations. If an accommodation would require eliminating an essential job function, it may not be reasonable. For instance, a construction worker who cannot lift heavy materials may not be accommodated if lifting is an essential duty. Safety concerns can also constitute undue hardship, such as an emergency responder with a disability that prevents rapid response. Legal precedents have helped clarify the concept of undue hardship. In the case of U.S. Airways Inc. v. Barnett, in 2002, the Supreme Court ruled that an employer is not required to violate a seniority system to provide an accommodation. Another notable case is EEOC v. Ford Motor Co. in 2015, where the court found that an employer could refuse telework as a reasonable accommodation if the job required regular on-site attendance. It's important to note that employers must provide objective evidence to prove undue hardship. This requires more than just a cost-benefit analysis. Employers should document the reasons an accommodation is considered an undue hardship and explore alternative accommodations where possible. Understanding undue hardship is crucial for both employers and employees. For employers, it helps in making informed decisions about accommodation requests and avoiding potential discrimination lawsuits. For employees with disabilities, it provides insight into their rights and the limitations of those rights under the ADA. In conclusion, while the ADA requires employers to make reasonable accommodations for employees with disabilities, the concept of undue hardship sets boundaries on these obligations. By carefully considering the factors that determine undue hardship and staying informed about legal precedents, both employers and employees can navigate these complex issues more effectively.